Bismillahirrahmanirrahim. Assalamu alaikum. I am Naeem Akhtar Afghan, Chief Justice, Balochistan High Court. And first of all, I am thankful to Mr. Shiraz, the chair of SIRAB, who invited me to this occasion and allowed me a privilege to be here amongst the stalwarts. First of all, I will praise the recitation by Mr. Noor. The verse he selected for recitation was very appropriate with the occasion, and his recitation was very inspiring. So I would request to applause and clap for him. I am glad to see the stalwarts, former Chief Justice of Pakistan, Honorable Justice Tasadduq Hussain Jilani, former Judge of the Supreme Court, Justice Mushir Alam Sahab, former Judge of the Supreme Court, Justice Atar Saeed, amongst us today. These are the stalwarts who have authored number of judgments, leading judgments, I would say, for our guidance. We follow their judgments and we have learned a lot from their judgments, as well as from their conduct as judges of the Supreme Court. I am glad to have Mr. Bhatti Sahab with us, Chief Justice of Lahore High Court, and I had the occasion of meeting with my brother judges from Islamabad High Court, from Lahore High Court, from Sindh High Court, from KPK High Court. And I am seeing the shining faces of young lawyers, some of whom are also barristers, and we all are thankful to the management of SIRAB for providing this great occasion. Ladies and gentlemen, I appreciate all the efforts so far made by SIRAB for establishing the Chartered Institute of Arbitration in Pakistan as a branch, office of UK. I inquired yesterday from the management of SIRAB, and they told me that they are providing training to the lawyers in 3 different tiers to make them aware about the ADR system, about the mediation process, about the international arbitrations. They are doing a lot, and inshallah they will succeed in the days to come with more success. I have gone through the brochures and the literature which was provided to me by SIRAB, and it reveals that SIRAB is promoting ADR as the first mode of dispute resolution. And in this regard, it has conducted 3 different events. And as far as I have seen, its prime object is to resolve the commercial disputes through ADR mechanism, so that to avoid the rigors of trials of civil court and to avoid the complications of civil procedure code as well. But today I will take you further with regard to some other aspects as well. And I came to know through their literature that SIRAB is going to blend Arbitration Act with ADR. Let's see how it is possible in the days to come. Ladies and gentlemen, the question arises, I will be little inquisitive today as well, and some of my questions may irritate you, but I am sure the questions which I will be putting to you will keep you thinking when you leave this auditorium. And for that matter, I will have to give some figures. Ladies and gentlemen, there is a data. We should go by data. It is the era of IT technology, and unless you have data, you can't adopt any technology, nor you can take any benefit of any technology. So let's have the data. The latest data is of today. In Supreme Court, we are having pendency of 53,200 cases. In Federal Shariat Court, we are having pendency of 104 cases. In Balochistan High Court, we are having pendency of 4,951. And in lower courts of Balochistan, throughout Balochistan, we are having pendency of 16,312 cases. In Lahore High Court, we are having pendency of 1,80,000 cases. In lower courts of Lahore, Punjab, we are having pendency of 13,87,000. In Islamabad High Court, we are having pendency of 17,500 cases. And in the lower courts of Islamabad, we are having pendency of 51,500 cases. In Peshawar High Court, we are having pendency of 42,718 cases. And in lower courts of Peshawar, we are having pendency of 2,66,038 cases. In Sindh High Court, we are having pendency of 85,728 cases. And in lower courts of Sindh, we are having pendency of 1,24,767 cases. In all, we are having pendency in the High Court, total pendency in the High Courts of Pakistan, it is 3,84,201. And in the lower courts of Pakistan, we are having pendency of 18,45,627 cases. And if you sum up, we are confronted in Pakistan with total number of cases of 22,29,828. Now, coming to the point, we are having a very heavy backlog, and all the judges in Pakistan are working day and night, but this backlog is not decreasing. Why? Answer, there are many answers to this question. Khwaja Sahab said, Khwaja Ahmad Hussain Sahab said that parties' conduct is cause of the delay. Justice Shahid Jamil said, lawyers are the regulators and lawyers' conduct are the cause of delay. And I will have some difference of opinion with Mr. Justice Shahid Jamil. These days are the days of difference of opinion, and difference of opinion is significance of independence of mind as well. So, with due respect with Mr. Shahid Jamil, sir, the lawyers are not the regulators of the proceedings. We, the judges, are the regulators of the proceedings. I remember one cartoon. I saw a cartoon few years back in a newspaper. A man was dragging a cow from its head, and at the bottom it was written plaintiff. In the same picture, the other man was dragging the cow from tail. At the bottom it was written defendant. And in the mid, a man was sitting with a bucket and he was milking the cow, and at the bottom it was written lawyer. With due respect, a legal fraternity has to earn his livelihood by rendering services. I myself remained lawyer for 22 years, and I have many stories to tell you with regard to the professional capabilities, professional integrity, and professional efficiency. And I am at the bench for 12 years, and I have many stories to tell you as a judge of the High Court. My opinion and my view is, whatever system you adopt, it works. It works efficiently when we, all the stakeholders, the litigant, the lawyers, and the judges work with sensitivity, with responsibility. It works, and I can prove with examples. And when whosoever is lagging behind or is not sensitive or is not taking interest, the whole system collapses. I can quote the examples. What a lawyer is. In Quran, Wakil is defined as Wasila. I, during my profession, was having this perception of my profession as a lawyer. I was the Wasila. I was the instrument to take the aggrieved to the appropriate forum for redressal of his grievance. An aggrieved person comes to a lawyer in a raw form. He has a bunch of documents. He has been aggressed. Someone has grabbed his land. Someone is teasing his daughter. Someone is not vacating his shop required by him for personal use. Someone has falsely involved his son in a murder case. Someone wants to get punished the real culprit who has caused injury to his family. So now he is not aware where to go. He only knows to knock the door of a lawyer. Now it is for the lawyer to choose the forum. Either he has to take him to the court of civil jurisdiction, he has to take him to the high court for writ jurisdiction. You are the wasila. He don't know how to get his son free from false allegations of a murder case. You have to architecture, you have to make a defense, you have to conduct his trial. He want to get divorce for her daughter. You have to take him to the court, you will proceed, you will lead evidence, and you will get the judgment. So you are the wasila, you are the instrument, and no doubt, to be a lawyer, the legal profession is of the same sanctity as the judicial institution. So my humble submission is, when you are thinking of ADR, when you are thinking of mediation, you must take on board the stakeholders. The main stakeholders are the lawyers. As far as I have gone for the ADR mechanism, I have discussed the same with bar members. In Balochistan, we have taken on board the lawyers in the first instance so that they may be able to digest this system. Otherwise, plainly thinking, the lawyers will be deprived of litigation. They will be deprived of the brief. If a judge has 20 cases and in 10 cases parties consent for alternate dispute resolution, the lawyer is losing the 10 cases and he will get scared that my practice is going to be finished. So please open a window for the lawyers, and government should think that the lawyers of integrity and good reputation should be taken as mediators. They should be well compensated so that they may have some adjustment of the financial losses which they will suffer in case the ADR mechanism is adopted with success. Presently, there is some scaredness. What I did in Balochistan, Supreme Court took the initiative that alternate dispute mechanism should be adopted in all the provinces. In the first instance, I called the members of the Bar Council and I asked them to constitute a delegate of lawyers from different age groups, and I sent them to 3 provinces for a study tour. Go and study KPK, go and study Lahore High Court, go and study Sindh High Court, what they have done in respect of ADR mechanism. And I availed the cooperation of the lawyers in the first instance. And resultantly, we started ADR system in Balochistan. Let me give you a resume. The ADR mechanism in Balochistan province is supported by UNDP. We are having a project in UNDP in Balochistan as Amno Insaf program, and they are financially supporting us. And we are adopting the court annexed ADR. Presently, we are adopting the court annexed ADR mechanism in the province, and we have also made legislation in this behalf. The officers, the legal officers, including my judges of the High Court and lawyers, they planned tours in different provinces in the year 2021, and whereafter we were able to promulgate Balochistan Alternative Dispute Resolution Act 2022. After promulgation of this act in 2022, we have established 2 mediation centers by posting 2 serving judges as mediators, and recently they have decided 8 cases through mediation. And we are expecting that number of family cases will be referring to these mediation courts. Apart from the commercial disputes, I have the vision to involve the criminal cases as well, because the cases involving human injuries under Qisas and Diyat ordinance, now they are part and parcel of PPC. Even in murder cases, compounding of offences is permissible by the legal heirs of the deceased, as well as in case of injured, it is permissible with the consent of the injured. So I am anticipating that in the days to come, we will be having criminal cases as well to these mediation centers for effecting compromise and compounding of the offences. Similarly, I foresee family matters as well as the matters of inheritance. As I say, there are two parties to the litigation. Delay is suiting to the one party, and the other party is having anxiety of quick disposal. Similar is in commercial disputes. In commercial disputes as well, one party is anxious for early disposal and the other party is having delaying tactics. So we have to regulate the proceedings, and we the regulators are heavily burdened to shoulder the responsibility. Today, in the first session, words were said about execution of degrees, misery of litigation. My view is that degree is not enough. Either you adopt any mode. You may have normal litigation under CPC, or you may have any mechanism, alternate dispute resolution or arbitration. End of the day, you can't avoid judges, because whatever the verdict is, it has to be made rule of the court, and that is by the judge, by the judgment. So again, a judge is there. So we have to be responsible, we have to be sensitive. Otherwise, no system will work. Every system has complications. I can tell you number of stories in Arbitration Act of 1940. There are certain provisions we will be dilating upon tomorrow's session. I have seen the issue of court fee on the memo of appeal in arbitration matter went up to the Honorable Supreme Court. And it took years. So what was the use of that act? Then I can quote you examples with regard to the appellate jurisdiction in arbitration proceedings. Specific provisions have been provided, specific orders have been mentioned which are appealable under Arbitration Act 1940. But we opened avenues in revisional jurisdiction for redressal of grievance to attend certain point, and on an interim order, a revisional matter went up to Honorable Supreme Court and remained pending for years. So we can't say that every system will work. Yes, it will work if we evolve an efficient mechanism. Unless an efficient mechanism is not involved, no system will work. In the second session, it was opted that chartering the course of mediation in Pakistan. Should Pakistan be a signatory to the Singapore Mediation Convention? Yes, Pakistan should be a signatory. Why we are delayed? Why it is so late? Why the government is sleeping? I don't know. We are all talking here today, and end talk is about legislation. I am feeling a lacuna in this auditorium, in this workshop, in this seminar today. With due respect to Barrister Shiraz, I am not seeing any legislator in this auditorium. Why? We are discussing all the problems and the solution lies in legislation, but we are not having legislators here. We the judges cannot make the law. You the lawyers cannot make the law. We can interpret the law. We can apply the law. We can struck down a law which is in contradiction to the fundamental rights as guaranteed in the Constitution, but we cannot make the law. So who has to make the law? It is the legislator, but they don't have the priority. 75 years have passed. Today we are talking about the judicial system, and we all are convinced that it needs robust reforms. There is no second thought. I will not say that system is failed, no, but it has to be made more efficient. I am judge of the High Court. I have practiced law. I will never say that our judicial system has failed. No, it has not failed, but it needs reforms. It needs reforms in all tiers. Justice Asif Saeed Khosa was with me in a meeting, and before taking oath, he shared with me in Quetta. He came in a bench and said, I am of the view that we should less the tiers of litigation. I said, sir, how? What is the idea? And my lord said, I am of the view that in civil court, we should have only one district court. No civil judge, no senior civil judge, no additional judge, only one district judge, dealing with civil cases as well as the criminal cases. And one appeal to the High Court and second to the Supreme Court. I want to less one tier. I said it is a very good idea and you can reform. But when he took oath, he failed to reform. I went to Iran for a study tour. In Iran, what was surprising for me, after a judgment of the trial court, when an appeal is filed, the system in Iran has left it to the wisdom of the appellate judge to go through the appeal in chambers, to go through the record, and if he is of the view that the judgment of the lower court is not suffering from any error or illegality, he may uphold the same in chamber and dismiss the appeal in chamber without giving any right of audience to the parties or counsel. And if he is of the view that judgment is suffering from any legal infirmity or lacuna, he may order to fix in court and call the parties or their advocate for arguments. It was very surprising for me. I shared this idea with Honorable Justice Guzar Sahab when he had taken oath as Chief Justice of Pakistan. I was having a Federal Review Board meeting in Karachi, and Justice Guzar Sahab was in Karachi heading a bench. So Justice Manzoor Malik was with me, and he said कि चलें जज साहब के साथ चाय पीते हैं, उनको मुबारकबाद भी देते हैं. We went to the chamber of Justice Guzar, and I asked permission from my lord, the then Chief Justice of Pakistan, to say few words and make few suggestions. And he permitted me कि कहिए कहिए बात कहिए. My lord, I said, sir, I have seen this Iran and I suggest that Supreme Court is going to change the rules. A committee has been constituted to revisit the Supreme Court rules, and I suggest, my lord, before you that the petition for leave to appeal should not be fixed in court before the two judges. It should be marked to a judge of the Supreme Court in chambers, and it should be left to the wisdom of the judge of the Supreme Court to go through the record of the lower courts, to go through the judgment of the High Court, and system should leave it to the wisdom of the judge of the Supreme Court, because it is a court of law, not the court of fact. If a judge of the Supreme Court sitting in chamber after going through the record is of the view that the judgment is proper, list has been decided properly, he may refuse the leave in chamber. And if he is of the view that there is a legal infirmity, there is a lacuna which needs to be rectified, he may grant leave to appeal in chamber, and in this manner, as per my estimation, we will get rid of 35,000 cases in Supreme Court. But he said it is a good suggestion and we will discuss in the meeting, but things did not mature. So we have to take the things, we have to carry the things, and we have to, actually we have not passed the process of evolution despite passage of 75 years. They have tailored the system. UK was having the same system, but they have tailored the same. We have failed to tailor the same. So we are facing, even today we are facing. Legislatures, they don't have the priority to legislate for the common man. yes, they do legislate for themselves. They have done with retrospective effects, but not for the common man. They are not ready to legislate for the common man. We are talking here today for the common man. So we should think, but my humble submission is to Barrister Shiraz, next time in the session you must invite the legislators. Secretary Parliamentary Affairs should be here. Minister Law should be here. Parliamentary committee members should be here. Members from Senate should be here. Members from National Assembly should be here. So that we may sensitize the issue. We may make them realize why the people of Pakistan are suffering, because they are not evolving the system. They are not bringing the required legislation. I am taking your time. I am sorry. I am engaging you in the late evening, and the credit goes to Mr. Shiraz. In the third panel, the construction disputes in Pakistan and how should Pakistan deal with CPEC disputes. Don't take me biased. I am a Pakistani citizen performing my duty in Balochistan. The question to the House is why we are discussing CPEC issues while sitting in Lahore PC. Why not Gwadar PC? Unless and until you put your feet on the ground, you will not be able to realize the ground realities. You will not be able to realize the real problems. The mainstream of CPEC is Gwadar. I am very happy to travel on CPEC roads in Punjab. I am really happy to travel on CPEC roads in Sindh. I am really happy to travel on CPEC roads in KPK. I am not aggrieved, absolutely not. But the question is, it is the question to the policy makers. We, the judges, cannot interfere in policy. Policy decisions cannot be interfered under Article 199 of the Constitution. So I am putting a question to the policy makers. Why the first CPEC road was not started from Gwadar? Why? Which is the mainstream of CPEC. You may enjoy the roads in your sister provinces. If you don't have a CPEC road in Balochistan or Gwadar, how will you transport the commodities from Gwadar deep seaport to South Asian countries, to other cities of Pakistan? So, wrong policy decisions have given rise to insurgency in Balochistan, which is combated by the law enforcement agencies. We have provided space to our enemies to instigate the miscreants. All the citizens in Balochistan are very patriotic. The people of Makran are very patriotic. They are very educated. Just you come and you have interaction for yourself. You will find PhD Baloch ladies, you will find PhD Baloch boys. You will find PhD Baloch boys in Pashtun areas, far-flung Pashtun areas, having PhD from Germany, having PhD from Thailand. You will be confronted with female Baloch girls who were having education and matriculation from far-flung villages and going to PhDs to Thailand, having meritorious results. I had been on the board of university for selection, and I have always surprised. The Baloch boys and girls, highly qualified Baloch boys and girls, highly qualified Pashtun boys and girls are coming for interview, for appointment as lecturers, for appointment as associate professors. And whenever I came from those meetings from universities, I share with my brother judges that I am seeing a greater, brighter Balochistan. I don't know who the insurgents are. I don't know them. And I tell you, we are with the concept of justice at the door. And we, with the concept of justice at the door, have established courts in far-flung areas of Balochistan, where my judges in the subordinate judiciary are performing their duties without any fear. We have two circuit benches, one at Sibi, which is at a distance of 2.5 kilometers from Quetta, and we are having a circuit bench at Turbat instead of Gwadar. Again, an option by the legislators. And for Turbat, we have to travel 10 hours by road from Quetta, or we have to take flight to Karachi, a night stay at Karachi, and then to Turbat. And Turbat and Gwadar are at a distance of 2 hours by road only. I have developed infrastructure in Gwadar. We have 4 terminal buildings in Gwadar. 2 terminal buildings are housed by district and session courts, and 2 terminal buildings are lying vacant now, awaiting international forums to come. But my government is sleeping. Still, 13 years have passed for CPEC. My bureaucrats are sleeping. My government is sleeping. Not a single endeavor has been made to bring international forums for dispute resolution to Gwadar, to Pakistan. My colleagues have named the institutions in Malaysia, in Dubai. They have done their homework, so investors are there. We have not yet done our homework, and we are dreaming that investors will come. How the investor will come? They are very sensitive. They are going to see what the judicial system is. So we are to reform. Either we have to, or we are going to make these words and go home happily, having dinners, having chatting, having clapping, okay, fine, everything fine, very good function. But what is the practical outcome? Nothing. So we should be practical. At least I am practical. I travel by road as a Chief Justice deliberately in far-flung areas of Balochistan to convey message to the masses that there is no no-go area in Balochistan. And if a Chief Justice can travel by road with all threats, then anybody can come. So I request the House, I request the administrators, I request all the persons present in this auditorium to have a next session in PC Gwadar. I will facilitate. Let you have interaction with local persons. The real CPEC starts from Balochistan. And if you fail in Balochistan, you fail in CPEC, I tell you. In third panel, Madam Virginia Claudita said that, asked the question whether the judges of Pakistan have the capacity to decide the issues of CPEC contracts. Madam, don't undermine the judges of Pakistan. We all have the capacity and ability to decide any kind of matter, any kind of list which is brought before us. I have dealt with procurement cases in respect of 2 CPEC road projects which are just now started in Balochistan. The federal funded projects are governed by Pakistan Procurement Rules 2004, and the provincial procurement processes are governed by Balochistan Public Procurement Rules 2014. My brother Judge Asim Saab have said few words about bid security, performance security, and security for mobilization advance. The Pakistan Engineering Council has laid down standard bidding documents which are mandatory and which have been also approved by the ECNIC. In those bidding documents, the bid security for 28 days has been mentioned to be furnished by the interested bidder in the shape of bank guarantee, call deposit, or AA rating insurance company. But to avoid healthy competition in the relevant BEPRA rules, the AA rating insurance companies have been excluded to support the monopolist contractors having very sound financial positions. I have authored judgments to the government of Balochistan with instructions to amend the rules and to allow wide competition under the rules. We can deal with any case, we can deal with any matter subject to assistance rendered by the lawyers. So don't undermine the judges of the Pakistan. Mushalam said few words about IT solutions. Yes, sir, I do agree. I was lucky enough to be with my Lord in Automation Committee of Supreme Court, and we were conscious that there must be trainings. I was in America and I spent one day in Washington Academy, where I was surprised the judges of the High Court there, they have federal courts, were having a training of 6 months. Can we have training of High Court judges in Pakistan? Now we are akle kul. We mind if a lawyer come to the court कि सर लॉ ये कहता है और कानून तो अच्छा आप हमें कानून सिखाएंगे अब. So we are not absolute. We are not absolute. I, despite practicing law for 22 years and despite being a judge for 12 years, I am still a student of law. I am still eager to learn. So we are here to learn. I request Honorable Chief Justice, I will also request him personally in the next meeting that we should have a judicial academy for training of the judges of the High Court of, because we are not utilizing the IT technology in its true prospect. I have some judges who don't even know how to feed a number in their mobile. They have not even opened the laptop. They can't function the computer. So we the judges have to learn the information technology. In America they said, yes, we were having the same problem. Most of our judges were in old age and they were absolutely unaware of the information technology. We made it mandatory for them to be trained in academies, and now we are having paperless litigation. We are having paperless courts. I also dream for the same, but for realizing that dream, we need training. Our judges need training. Our lawyers need training. So we all need trainings. Asim Hafiz also said few words about change of culture. I do agree. Reform is not only required in the judicial system, but reform is also required in the society. We have to educate the litigant as well. A litigant must come to the court with whole truth. A complainant in a murder case must come to the thana, to the police station for lodging FIR with whole truth, without any fabrication. If we achieve this object, frivolous litigation will be lessened. My task, I say, that in a murder case, I am always in trouble in a murder case because I am confronted with false evidence, with false witnesses, and I have to search truth from the false evidence. Almighty blesses, Almighty guides. That's the another phenomena for a judge. Time. I'm sorry, I'm coming from Quetta far away. I will take my time. I'm sorry. So we have to reform the society as well, and I would urge the litigant to come to the court with whole truth. In the end, I am conceding to your request because I am a judge, I have to honor your request. So in the end, I agree, yes, we have to make robust reforms, yes. Corruption has to be eradicated from the government departments. The corruption, nepotism, and bad governance in government departments has burdened the High Courts with writ petitions. If this aspect is controlled, our writ petition will be lessened. It is high time for us to reform in the judicial system at all levels. Society also needs reforms. Judges and lawyers need trainings. Sensitivity and responsibility of lawyers, arbitrators, judges, and mediators is need of the time. And we have to adopt different strategies for clearing the backlog. And in the end, I will say thanks for patient hearing. Thank you very much.